For the past few weeks, 900 residents of Colleton County received a jury summons from the clerk of court for the highly anticipated trial of disbarred attorney and accused murderer Alec Murdaugh. This trial is scheduled to begin on January 23, 2023 in Walterboro, South Carolina. Murdaugh has been charged with the murder of his wife and son at their Islandton home in Colleton County on June 7, 2021. Given Murdaugh's deep ties to the community, the selection of a fair and impartial jury has been a hot topic of discussion across South Carolina leading up to the trial. The process of selecting a jury is a key component of ensuring Murdaugh's right to a trial by an impartial jury. Today, we're going to take a look at how this process works. The jury selection process begins every year in September when the South Carolina Department of Motor Vehicles sends an electronic file to the State Election Commission. This file contains the name, address, date of birth, social security number, sex, and race of anyone who's over the age of 18 years and are citizens of the United States who hold a valid South Carolina driver's license or identification card. The file also includes the names of people who obtained South Carolina driver's licenses the previous year and excludes persons whose driver's licenses or identification cards have not been renewed or have been invalidated by judicial or administrative action. In October, this list is then sent to the jury commissioners for each county. The jury commission is often the clerk of court or deputy clerk of court for the county, but in some instances it is made up of multiple county employees. So for example, in Lexington County, the county auditor, the county treasurer, and the clerk of court of common pleas serve as the jury commission. This list provided by the State Election Commission becomes the official list of eligible jurors in the county for each year. The jurors are selected in each county by a computerized jury management system, which is managed by the clerk of court or deputy clerk of court of the county. According to the South Carolina Code of Law, these programs are designed to, quote, ensure a random selection of jurors from the population available for jury service, end quote. The law also states that the drawing and summoning of jurors, quote, must take place in the office of the clerk of court as a public event to ensure the absolute integrity of the random selection process, end quote. Prior to computerized jury selection, a jury box was maintained by each county containing the numbers that aligned with the potential jurors on the list that's provided to them by the State Election Commission. Before that, local youths often served as jury boys and would draw the names of jurors in court for $5 a day. After the jurors are drawn, the clerk of court is responsible for notifying or summoning prospective jurors when they have been selected for jury duty. The law requires that a juror must be notified of selection for service 15 days prior to the start of the term for which he or she has been summoned. The 900 residents of Colleton County who received these summons also received a jury questionnaire. According to our legal analysts, this is highly unusual and is a practice typically utilized in death penalty cases. In December, the Attorney General of South Carolina announced that they will not be seeking the death penalty in their case against Alec Murdaugh. When the jurors arrive on January 23, 2023 to report to duty, they'll be sworn in by the Clerk of Court, Rebecca Hill. How long jury selection takes is anyone's guess, but after the jurors are sworn in, they will begin the process of voir dire, which is a preliminary examination of a juror by a judge or counsel. During this questioning, which is not allowed to be viewed by the public, attorneys may challenge any of the jurors for cause. An example of a challenge for cause would be somebody who said they went to high school with Alec Murdaugh. The defense or prosecution could choose to challenge this juror if they feel the relationship would cause them to be biased in their deliberations. Challenges for cause are not often approved by the judge, because if one is raised, the judge will simply ask the juror if they feel that the relationship would cause them to be biased in their deliberations. If the juror responds that it would not affect their judgment, the judge could simply deny it. The right to serve as a juror is a strongly held right in the court system. After the attorneys get through the challenges for cause, they begin using their peremptory challenges. An attorney does not need to provide a reason to excuse a juror for a peremptory challenge. Once that process is completed, the jurors' names are called using a randomized computer system, and the names are presented to the court. After the juror's name is presented, the prosecutor is asked what the state says. Their responses are to excuse the juror, present the juror, or swear in the juror. If excused, the jurors are seated at the back of the courtroom. The defense is asked the same questions. The process is repeated until 12 jurors and alternates, which we are told will likely be 4 to 6 in this case, have been seated and sworn in, at which point jury selection has concluded and the judge will allow the opening arguments to begin. For more information on jury selection, check out our in-depth article on FITSNews. It also includes information about the questionnaire that the jurors summoned for the Murdaugh case received.